This is the In Focus podcast from The Hindu.
Hello and welcome to another episode of the Hindus in Focus podcast. I'm Zubaida Hamid, your host for today. Last week, G.N. Saibaba, a former professor at Delhi University, died after being released from jail in March this year, having spent 10 years incarcerated. Professor Saibaba was jailed on terror charges but was eventually found innocent by the Bombay High Court. The court, while acquitting him, had criticized both the investigation and the trial court's decision in finding him guilty in the first place. Despite being 90% disabled and on a wheelchair due to polio, Professor Saibaba, as per his own account, was constantly denied access to medical care while in jail, denied medical bail during the pandemic, and denied emergency bail during the death of his mother. His case highlights once again the problematic issue of bail in our criminal judicial system. Who has access to bail? How is bail given, and can bail conditions be met by those seeking it? Does our system privilege the wealthy and leave out the vast majority of others? Is not being able to access or not being granted bail behind the problem of the huge number of undertrials in Indian jails and the overcrowding of the system? We delve into these issues and more with Medha Deo, Program Director, Fair Trial Program of Project 39A from the National Law University, Delhi. Hi Medha, welcome to the Hindus in Focus podcast.
Hi, Zubeda. Thank you so much for having me on this.
Medha, of the many things that emerged from the case of Professor Saibaba, who died last week, one of the things was the repeated denial of his medical and emergency bail while he was incarcerated. Could you talk to us about this?
This was a classic case of systemic violence, and one of those cases where the accused was actually in a position to make attempts to be able to claim their right in court, and yet there was no relief. So, Professor Sai Baba had been released on bail early in 2015 and on health grounds for once, and after 3 months he was asked to surrender despite the fact that there was no non-compliance of bail terms. He was denied bail subsequently, and later in one of the appeals for bail that was made before the Supreme Court, in fact, noted and said that it was unfair that this bail was denied to him, given that he had never actually non-complied with the bail terms. And yet, even after that, there was denial of emergency bail, medical bail during COVID, which was being given almost routinely to most people. And given Sir Sai Baba's condition, it was only legitimate that it was granted to him. Later, after that, he was denied parole, emergency parole, on the death of his mother. I mean, despite having instructions from Supreme Court, time and again the lower courts were denying him bail, and the system just ensured that he remained in custody.
You call this a classic case of systemic violence. Let's talk about that a little more in terms of the issue of bail that has been a problem in our criminal justice system now for decades. The Supreme Court has said over and over again that its mandate is bail and not jail, but why does this not work out on the ground?
So there are obviously many reasons, and it's not simple. There is no simple answer to it. I'll try to break up into certain points. So to start with, we don't know what the problem with bail and its correlation with overcrowding is. The way the system functions, we do not have any official data on the number of bail applications filed, how many people have been rejected bail, granted bail. So, when we talk about the problem of bail, we don't know if it's an issue of bail not being filed, bail not being granted, or there being delay in the timeline in the way bail adjudication is done. All we are talking about here is anecdotal to start with, and that's one part of the problem. The other thing I like to sort of always bring up is it's interesting to see most of the liberal bail jurisprudence that comes from the Supreme Court. If one were to look at it, they are almost all these case laws. If one were to look at Antil, Chidambaram, Arvish Kumar, all of these are in cases which are of economic offenses or offenses against women, where obviously the accused has a certain kind of resources to be able to reach the Supreme Court and then for the Supreme Court to adjudicate on this. The mass of the problem of bail is obviously in petty offenses, which are, in our experience, mostly theft in a dwelling house, or a lot of railway court related offenses, which are cases where bail is routinely denied or is granted in a manner where it is completely infructuous, and the issue does not even reach the Supreme Court. So, there is obviously a huge disconnect between the way the apex court looks at bail jurisprudence and the way it is decided at the actual trial court or remand court level. And again, for that, there can be multiple reasons. And I'd like to quote Justice Oak. He was speaking at one of our lecture series lectures on access to justice, and he was very candid in saying, and this lecture is publicly available, to say that we do not have a culture of appreciating judges who are giving people out on bail. So judges who are actually allowing people's release, they are under pressure from media, from society, because at some level, at the very basic level, as citizens, we do not understand the difference between bail and acquittal, and it's seen as a systemic failure. High court judges or senior judges do not see it very favorably. And in person, I've had conversations with judges who've said that, or in fact, there are cases where we are representing people, and the judges have noted that you can go to the High Court and they will allow you bail, but there is a certain fear and reluctance within the trial courts and the remand courts to allow people out on bail. So it's also that culture of a good criminal justice system being perceived as one which punishes as many people as possible, which keeps as many as people as possible in custody, that can be blamed here.
So, an entire culture where the trial or the lower courts just do not want to give bail and would rather pass the buck on to the higher courts?
Right. And just to add to that, there is obviously a very genuine fear of people absconding. And if one were to look at the demography of people who remain in prison, like let's say if we were to look at prison statistics, most of the people are very poor on socioeconomic indicators. And if one were to look at classic guidances that Supreme Court gives on bail, which is the so-called liberal jurisprudence, which would say that unless there is fear of a person absconding, unless there is fear of their attendance not being possible in court, bail should not be denied. Now, but what we are looking at as the larger pool of people who are seeking bail actually fall within that exception that forms part of the liberal jurisprudence. So, most people who seek bail actually do not have property, or they do not have property connections. They might be from different districts. So then judges, in applying their discretion, you cannot entirely blame them for using this sort of their discretion to ensure that the person remains in custody, rather than to take the risk of releasing somebody who is, and again, this is a perception the system has built over years, that a person who has property, a person who has money, is less likely to abscond, which again there is no empirical evidence to say, because then it is the same government which is paying money for people's PR bond. So how less likely is a person to abscond if the money for bail is being paid by a third party? So, there is just that logic doesn't fit in, that courts will give stringent bail condition and the government is now creating a fund to pay for those stringent conditions, as opposed to the courts could just have given liberal conditions for release.
Talk to us about this a little bit more. So, basically, the bail system as it works now privileges those with access to money, land, resources, or those with connections to these things and leaves out the vast majority of people who don't have this access?
Yes, that's how the bail system is designed. And it's not only a problem in India, that's an inherent critique of the bail system, that it works on the assumption that of property and property connection. So you're either required to submit papers of property tax, or you need somebody who has solvency certificate who is willing to vouch for you. But this person willing to vouch for you has to be, so it's typically called a solvency certificate. And there are few cases where there are cash bails which are in petty offenses, but and sometimes these cash bails are as low as 5,000. And in the cases where we work, clients we work with are absolutely unable to pay for the 5,000. So, it's in fact ironic how a person who would have been accused of stealing somebody's wallet, which might have, let's say, 2,000 or 3,000 rupees, is then incarcerated and is then being asked to pay a money of 5,000 rupees, or to get a person who has a certain solvency standing to stand and vouch for him that he will or she will not abscond. So it's about how fructuous is a bail order, even when it is granted. And I mean, the judicial logic there is that if a person has submitted money in court, or if there is a person who has a house, there will be some way for the police to find this person if they abscond.
So, you said the vast majority of people who are not getting access to bail are those jailed for petty offenses. Talk to us a little bit about the under trial situation. Do they then end up serving long years in jail without their cases coming up for trial, sometimes even longer than what the sentence for the offense would be?
So now with the system of checks and balances, there aren't, thankfully, there aren't too many people who are there in jail for a number of years longer than their maximum sentences. The old 436A has, and with the under trial review committee, I mean, it's not the most efficient system, but there is some semblance of functioning for that. But we, in our experience, have still got some cases which would be exceptions. I would say, I wouldn't say that's the norm, but one does come across cases like this. For example, in 2019, we had represented somebody who was caught under the NDPS Act, and they were charged. They were charged with an offence which had maximum punishment for 12 months, and we came across the case in the 13th month of custody, and courts were not aware. Courts had not taken cognizance of that. I mean, obviously, then the DLSA stepped in, and there was, and then if it comes out, the person is obviously released. But what of the reparation is, and the class of people we are talking about, they do not have that sort of entitlement to even question why they were there for an additional month or to claim compensation, and system obviously does not facilitate it. The population of under trial prisoners in India is a known fact. It's around 75.8% or 2% right now. And this has steadily been growing in the past. So I think in 2018, it was close to 70%. And by now, it has come up to 75%. And the interesting part is this is data published by the prison statistics. But the prison statistics methodology of collecting data does not count the flow of prisoners. So the actual inflow of prisoners, let's say those who would have come in on a January 1st of a year and would have gone out before a December 31st. In fact, that data is not that data of prisoners who have been under trial for less than a year has not even been accounted for in the PSI. So the actual numbers of people who are under trials is much higher than what is there in the prison statistics.
And do you think lack of access to bail, because of the many factors that you pointed out, the fact that they don't know how to access it, there are delays, sometimes you can't pay the bail, sometimes you just don't have the resources to come up with the amount that the court decides, is that, do you think, a significant contributor to the overcrowding in the prison system?
Of course, that is, in my assessment, that is one of the biggest contributors. I mean, the other part I feel is just the number of indiscriminate arrests that we get into. And I mean, there's an inflow issue as well. And there is a mismatch between the number of people who are brought in on a daily basis and who go out on a daily basis. And the number of people who are brought in on any given day for any given prison is much higher than the number of people who are released. So, I mean, it's a determinant of these two factors: high arrest and low release. The other thing that feeds in because of lack of bail, and it has come across in a lot of our cases, that people plead to their offense. They plead guilty because, let's say, people who are charged with multiple petty offenses in cases, there is a systemic push because it makes the court's job easier, it makes the prison's job easier, it makes the lawyer's job easier a lot of times, to convince the accused that if you were to admit to your crime, you will be let out on the time you've undergone in the prison. And most of the times people end up pleading guilty because it seems as the only resort for them to step out of prison. Because let's say I've had a bail order of x amount or x condition where I have to give papers of property, and I know that realistically I will never be able to achieve it. And I'm given a window where by pleading guilty my period of incarceration will be set off against the punishment I'm going to. So then this person will plead guilty and go out, or maybe they will stay in prison for a shorter period of time. So what ends up happening is there is also a higher conviction rate then, and a longer stay in prison for whatever, as convicts, for whatever remaining period that person is staying.
So it's easier for them to admit to it rather than wait for the prosecution to actually prove the case against them.
In a lot of cases, yes. And we've seen this. Plus, also, I mean, if one were to look at the way petty offenses are charged, mostly it's a trend where a person comes under the police's radar for, let's say, one petty offense, of which could be a pickpocket in an area, which they may have actually done. But the pattern then emerges that every time a pickpocket incident happens in the neighborhood, the police is likely to pick up and charge this person, especially if it is FIR against the unnamed person. So most people who are involved in petty crimes, then they end up getting involved in a series of cases. They're not able to navigate through. Every time they come out, they're charged with another case. They come in. So what we talk about, the revolving door of prison. So that happens, and sometimes they get so overwhelmed where they have been charged with like 10 or 15 cases, and they feel there is absolutely no way out for them. Even if it's a bail amount of 5,000 in 15 cases, they think they will not be able to manage it. And so they start accepting their guilt without understanding that just this sort of false admission of guilt is making them further vulnerable, because now they are proclaimed convicted offenders, making them further vulnerable to arrests and being on the radar. But yeah, this happens all the time.
Talk to us a little bit about the role of the police here. So, how does the law, there's supposed to be default bail in the absence of a charge sheet within a 60 or 90-day period, correct? But how does this work out in reality? Does this actually happen that when there is no charge sheet within 60 or 90 days, the person does get default bail?
Yes, so in law, it does happen. And in most cases, if there is a lawyer who is raising this question, if there is no charge sheet file, the person is allowed a default bail. The conditions again remain questionable. Whether those conditions on which the default bail is granted are actually helping in release or not is something which one cannot predict. So, all the other problems of bail compliance that I spoke about earlier will also have problems on bail compliance for a default bail. In addition to that, there is sort of, I mean, police is mostly filing charge sheets, but it is strange. Again, like I said, the approach and the use of discretion in so to say, um, trying to ensure public order, trying to ensure a crime free society, the use of discretion, mo- a lot of times, sort of the balance tilts in favor of the police. So we've had cases where we filed for default bail, and the judge has ended up asking the IO to show cause or to ask for their say before granting bail. Whereas if there is this default on part of police, this bail should come as a matter of right. So, and this is, the law does not allow this, but in practice we have seen this happen. And at the and for a theft case, you will not go to the high court in appeal, or you do not have the resources to go to the high court in appeal to say that this is what the trial court has done with us. Or maybe we will take that one case, but how many cases like that would actually have the wherewithal to go to the high court or the Supreme Court and point out that this practice is happening?
And does this also happen that the police file, say, a temporary charge sheet and then add to it as a supplementary charge sheet and keep on doing that in
Yes.
order to, yeah. Talk to us about that.
Yeah, that happens all the time because obviously they keep adding sections. So a lot of times the sections that were added in the FIR will be very different from what comes in the charge sheet, and there will be supplementary charge sheets filed. What also happens because of that operationally is a lot of times when people can probably get benefit of lesser like sections with lesser punishment for seeking early release under the erstwhile 436A, or what is 479 now. So because of these additional sections, you go on being charged with more serious offenses while you are in prison. So let's say, for example, there might be a case which was a case of attempt to murder, or there was a fight, and then eventually the victim dies. In almost all cases it gets charged with a murder case, whereas it might be possible that it's actually culpable homicide not amounting to murder, where there was no intent to commit murder. But those that kind of reasoning never goes into the way sections are added in the charge sheet, and the tendency is to always charge with the section which is most serious and which will entail the highest amount of punishment. The other thing which is interesting to look at here is the role of prosecutors, because, and it's not only in the case of default bail, in a lot of cases where the offenses are sort of serious, maybe charged with 7 years or 10 years, judges routinely ask for say of the IO or say of the prosecutor before allowing bail in the case. And that there is, again, it's almost never that the prosecutor um does not oppose bail for a person. So there is no reason for a person to be held back in custody if they are not a threat to the victim, if they are not in a position where they can influence investigation. There is no legitimate reason for the prosecution to oppose bail. But the prosecution opposes bail almost as a matter of routine. And what ends up happening is it ends up delaying the process of bail adjudication itself. So let's say if I were to file a bail today, the judge will ask for C of the IO or C of the PP. And it will take maybe another 2, 3, 4, 5, 6 dates for the PP to actually respond, to get adjournment. And when they respond, then to get into another set of argument before the court, where the PP will put their points and the defense will sort of oppose it. So this whole process gets prolonged because of the say of the PP. So I've also heard from my clients firsthand in cases that IOs have actually demanded for money just to appear in court and give their say, or just to appear in court for a say hearing. So, in that sense, there's also a certain economics to add to, anyways, the other dynamics and the undercurrents that happen in the criminal justice
So
system.
essentially, if you don't have access to a lot of money or know a person with access to a lot of money who can guarantee you, the more or less default position is that you will spend a long time in jail, even if your offense doesn't merit it.
Yeah, unfortunately, That is the truth.
Right.
I mean, that's something that data validates. That's something that experience validates. That's something that anecdotally. I mean, that is one thing nobody disputes, from the president of India to a trial court lawyer to a jail guard. I don't think anybody will dispute the fact that it is ultimately poor people who languish in jail. And if you have any resources, if you have access to resources, you have access to a lot of means to come out of prison, both legitimate and illegitimate.
So, would you say that the majority of our jail population is the poor, the marginalized, the minorities?
Yes, in fact, in our data, in the data of the Fair Trial program that we published for the first cohort, um, over 70% people were from socioeconomic marginalized categories. And I think close to 80% had special needs. So, there's obviously that category which may not be socioeconomically marginalized, but they will have needs of mental health, or illness, or there might be women who have children, there might be women who are pregnant, or there might be people who have just been abandoned by families. So that is another very big category of needs that emerges from prison. So people who are socioeconomically marginalized and people who have been abandoned by families, and there's a big intersection here for the people who have poor socioeconomic indicators.
That is shocking, the fact that so many of them have special needs.
Yeah, yeah. And what I haven't talked about till now is the role legal representation plays just in being able to claim your rights, or just in being able to sort of push for what is your entitlement, and how that plays out. Because I mean, unfortunately, while we do have great access to legal services, thanks to the Legal Services Authority, it's an underutilized system. We know that people do, it's not the preferred mode of representation that people use, for multiple reasons, again, not documented, but the sense is that I mean, people have this perception that anything that comes for free is substandard. They also feel that they will have lesser capacity to bargain or demand things of a state system. And to admit it is not the best possible quality of representation that you get through the legal services authorities. I mean, obviously, things are changing now with the LADC coming in. But it is not that these same people, if they are approaching private lawyers in trial court, it's not that the quality of representation that they get is phenomenally different. It pretty much remains almost at the same level, because obviously their paying capacity is limited. And yeah, I mean, the truth is that the amount of money you pay to your lawyer, or the amount of money you are able to pay to a lawyer, will sort of determine what kind of legal services you get, what quality of legal services you get, and how much interest the lawyer is going to take in your case. So all these factors play out. And so this, we are only talking about legal services. Now imagine this person also has special needs, and we're not even talking about, in the Indian context, I don't think there's even imagination of other support services which will be needed for a person to not only to navigate their life living in prison, but also to be able to navigate the legal process. So let's say, if you are somebody who is a suspected juvenile, you will need somebody who can do the running around outside to collate your papers, to go to your school, to get that paper in. Preferably a social worker or a para worker, which the system does not uh, clearly recognize. I mean, yes, there are paralegal volunteers, but their role does not involve helping people in getting this information, which is clearly not a lawyer's job. But at the moment, the system assumes that it will be the lawyer who's doing all this. So it basically ends up not happening. Similarly, if you're somebody with mental health needs, there is a person, in addition to the medical needs that you have as a person with mental illness, there will be a person needed to only collate history about your mental illness, to identify triggers, to also be able to collate papers relating to treatment, just to be able to put it in court to ask for whatever your needs are. And that kind of system does not exist, unfortunately. But if I were somebody who has the resources, I will have all these people at my beck and call available. So then then the quality of representation, the kind of points I'm able to put across in a court is just very, very different from what a person with no resources would do.
But as the case of Professor Saibaba showed us, who was in a wheelchair and had very high disability needs, even then, the courts did not allow him bail or did not allow him access to healthcare systems that he required. So,
Right. No,
uh,
but I mean, I would also say that in case of Professor Sai Baba, it was almost like the system was ensuring that all these measures failed. So I think in his case, actually, it was an exception in the sense that he did have support outside of prison and people were taking up his case. So it would have been much worse if he was somebody who had the fact that he was able to actually come out. I'm not saying that's justice. I mean, there was no justice if you've just been incarcerated for so many years for no reason. But the fact that there was some noise around it is because there was support outside of prison. It may not have been a lot of money, but there was social capital. But imagine there was Mr. Narote, who was a co accused in the same case. We haven't heard much about him. I was trying to look up. He died in custody of swine flu. He was the sixth accused and who was also acquitted. But he was an Adivasi person. I don't think any of these proceedings were followed for him. I don't think he was allowed bail. So I mean, yeah, so in that sense, even in this case, you are able to see that a person's capacity of what they're able to take off the system is very, very different depending on the kind of support you have. And I mean, in his case, at least there was family and social support, which unfortunately did not translate into much, but there was still noise being made about it. But there are so many other cases that you don't hear of otherwise.
right. May the last question, let's talk a little bit about what the Law Commission over the years has recommended in terms of what needs to be done with undertrials in the system, and does our bail system need an overhaul? What needs to go into it?
So, I mean, see, the Law Commission's report on releasing of first offenders on completion of one third of maximum sentence has actually been, to some extent, brought in the section 479 of the Bharatiya Nyaya Nagrik Suraksha Sanhita. Sorry, that's a tongue twister. So in the BNSS actually talks about it. But like I said, because such a vast population of offenders and people who are in actually arrested and stay in prison are actually charged and convicted, or they end up pleading guilty and looking as convicts, a very sizable proportion will not be able to take benefit of that section because of it being first time offenders. However, yes, of course, I mean, if somebody is purely charged for the first time and looking at it from a point of reform, the possibility of reform, it's a very welcome move that has come in. How much it ends up decongesting prisons is something one will have to see. And in fact, it's only the first UTRC meeting now that will happen after the first quarter of this act coming into play. So probably we'll see numbers of release and we'll be able to compare it with how many people were being released under 436A versus how many are being released under 479. But there's one interesting rider in section 479 as well, and I'll just read it out for you. It basically says that if any such person has been detained in any case before for investigation, inquiry, trial, or any of those things, he will not be released by the court on bail. So, which means another very sizable proportion of people who are not even convicted, but who might have been arrested for whatever reason and who are in prison, they will fall out of this if they are charged in multiple cases. So, again, what I explained about people having multiple cases and multiple convictions, that sizable proportion gets missed out. And the second part to see is what are the kind of conditions for release that come in. Ideally, they should be let out on PR bonds. But even under 436A, we have seen some courts applying stringent measures of bail conditions. So it's still the court's discretion to apply those kind of bail conditions, and how many people are actually able to come out is something one will have to see.
Quickly give us a idea as to how the bail system could be overhauled. Has any other country managed to do this?
I am not aware of any country. In fact, I mean, most places follow similar systems. With obviously uh, there are like some experiments that have been done. Like there's the Manhattan Bail Project, which is in the US, and which is very interesting because they have in that project they pay surety money for ensuring release of clients, but those clients who the project gets released, they've done background checks and they also work with them to ensure attendance in court. So that's a good experiment to also show that people do not necessarily abscond if they have all the resources to appear in court, and people are genuinely interested in getting cases settled, getting out of the system, getting out of the rigmarole of being trapped in multiple cases. So we do need an approach where the court or even the legislature is able to look at uh, alternatives to ensuring attendance in court, to ensuring smooth investigation, other than incarcerating people. And I would say it's rather convenient to just incarcerate people and say it's for the purpose of ensuring attendance, whereas our experience shows that people abscond in cases not as an act but more as an omission. They might have taken up work where they're not getting leaves to attend court, or they might have taken up work in another state and they are unable to come. Or a lot of our clients do not actually understand the difference between release on bail and acquittal. So a lot of times they are released and they are so scared of being back in the same system that they choose to remain outside, like they just to choose to stay as far as away from it as possible. Not to say that they are again going back into a life of crime, or they were in the life of crime for the first time. So yeah, so that kind of an approach where we are able to look at what are alternate measures which can be effective, I think that is something one needs to explore. Again, I'll go back to the first point I made. We don't even know what is the problem with the bail system. There is no data. We need empirical evidence. We need suggestions which are backed by empirical evidence to identify what are the problems. And generally, some sort of an orientation. I mean, the power of discretion in granting bail and bail conditions is wonderful, and I don't think it should be taken away. But in whose favor does this discretion go? Is this discretion in the favor of allowing liberty of a man who has no means to secure his liberty? Or is it going into the favor of a state in the name of maintaining order in the society and maintaining a crime free society? And where is the balance that one needs to do for this? I think is very, very crucial. And that's something that we, as a system, we need to think on.
Thank you so much for speaking to us today, Medha.
It's been a pleasure.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.